Well, the Supreme Court made a slew of decisions last week as this year's term came to an end.
And one of those rules that parents could opt their children out of lessons with LGBTQ children's books on the basis of religious freedom. Our legal expert, Whitney Traylor, is joining us now. And this is a case that was based on religious freedom and the principles there. So what was the court's reasoning here for parents?
Right. Well, so the issue was that in Montgomery County, Maryland, they introduced some LGBTQ books into the elementary curriculum just to have as part of the, not to necessarily teach that, but to have on the shelves and that kind of thing. And parents objected, and there were several parents that wanted to opt out. And some of the books, for example, one was called Uncle Bobby's Wedding, and this was about a little girl's reaction to going to her uncle's same-sex marriage. And there was one, Pride Puppy, where a puppy got lost in a pride parade. And so it was an introduction of those kind of principles. And so they had an opt-out option where parents could opt out if they didn't want their children to be exposed to those books. Well, it got too complicated, so the school said we're not going to have the opt-out. And so this group of parents, and it was a Catholic, a Muslim, a Ukrainian Orthodox, so it was a number of different religions that sued and said, hey, we should have this right to opt out. And it was based on this First Amendment freedom of religion, because it said this is not consistent with our religion. And the court, it got up to the Supreme Court. All the lower courts ruled against it, but the Supreme Court said, no, they do have this right to opt out.
And the court relied on a precedent from 50 years ago. It was an Amish case. So how does that case apply here?
Right, so the Amish case, it was Wisconsin versus Yoder. I think it was 1972, and there in Wisconsin versus Yoder, the Amish wanted to not have their children mandatorily go to school after 6th grade. But the law was, or after 8th grade, but the law was you have to go to school through age 16. And the court ruled in favor of the Amish and said this is their sincerely held belief, this is their religion, they can't be forced to, it wasn't compulsory. And so the court actually relied on that case, among others, but they said, yes, based on Wisconsin v. Yoder, these parents have this right to do it. And they really balanced, and it was a question of what standard the court should review the case. And so they balanced the school's desire, and really the school's argument was it was getting too complicated, having all these different people opt out, who could have access, and so the court said that doesn't override the parents' right to instruct their children's religious upbringing.
It reminds me of that whole sex education thing where you could opt out at different times, and that opened another whole can of worms.
And that was in the case. They discussed the sex education part of it.
So there's always dissenting opinions and some strong dissenting opinions here.
Yes.
Tell us a little bit more about that.
Well, in a number of these cases, it got personal on some of these cases between the concurring opinions and the dissenting opinions, where justices were naming each other. Justice Sotomayor read some of her dissent from the bench, which is somewhat significant. She even put, I don't know if it was the entire book, but in the footnote of her dissent, she put the text of one of these books to make her point. And here's her quote. She said, "This decision threatens the very essence of a public education because it strikes at the core premise of public schools, which is children can come together not to learn the teachings of a particular faith, but a range of concepts and views that reflect our entire society." So her point is, look, it's the exposure to the entire society, but these parents are saying, no, because, you know, believe in cisgender and heterosexual couples and marriages between a man and a woman, and this is completely inconsistent with
what I teach at home.
Exactly. And the court felt that that was a more compelling reason and therefore ruled in favor of the parents.
Interesting. We'll see how it impacts schools moving forward. Whitney Traylor, thank you.